Good afternoon. Please refer to the chat for instructions on translation between English and Spanish. If you have any problems connecting, please contact Monique Chow Norquist privately on the chat and avoid using the group chat. Just to tell you what the instructions for translations are. To activate the language interpretation option in Zoom, please select the globe icon located at the bottom of your screen that says interpretation. Then in the options menu, select the language of your choice, in this case, English or Spanish. It is necessary to select a language channel for the entire meeting. Remember that you can mute the original audio to avoid listening to both languages at the same time. If you have any problems connecting, please contact any of the hosts privately on the chat and avoid using the group chat. And a reminder that this event will be recorded. Good afternoon. Welcome to this discussion on the role of the judiciary in electoral contexts, a view from Latin America. My name is Amrit Singh. I am professor of practice at Stanford Law School and executive director of the Rule of Law Impact Lab. This event is being co-hosted by the Inter-American Dialogue and the Stanford Law School Rule of Law Impact Lab. We are honored to have three distinguished panelists today: Justice Barroso, Justice of the Supreme Federal Court of Brazil; Magistrate Salazar Marin, Judge of the Constitutional Court of Ecuador; and Justice Blanco, former magistrate of the Constitutional Chamber of El Salvador's Supreme Court. I will now turn the floor to Rebecca Bill Chavez, President and CEO of the Inter-American Dialogue, who will deliver opening remarks. Rebecca?
Thank you so much. Good evening, or actually afternoon for those of you who are in California. Thank you so much for joining us for today's event, which highlights the role of independent courts as bulwarks against democratic backsliding. Thank you so much to Amrit and to Tamara Tadasuk, who is director of the Dialogue's Rule of Law program, for conceptualizing and organizing this important conversation. The Dialogue, the Inter-American Dialogue, we're thrilled to partner with Stanford, and we look forward to expanding our collaboration in the future. On a personal note, it's especially excited. Actually, Stanford launched my career. It's where I received my PhD, and my dissertation was actually focused on today's theme: democracy and the role of independent courts. So when I wasn't in the political science department, you could find me in the law school. So as everyone joining us here knows, assaults on the rule of law play a central role in today's democratic recession. The threat to liberal democracy is no longer a military coup and an abrupt break in the constitutional order. Instead, what we're seeing is democratically elected leaders assuming power and then deliberately and gradually undermining basic guarantees such as judicial autonomy, electoral integrity, and freedom of expression. According to today's authoritarian playbook, one of the first actions is to strip the judiciary of its independence. And we've seen this happen across much of the Americas. But in contrast to this bleak picture, today we have the opportunity to focus on the positive. We're going to hear about courts that have fulfilled their constitutional role of checking the abuse of executive power. In June, for instance, Mexico's Supreme Court exercised judicial review and overturned for the second time a change to electoral laws that would have favored AMLO. But as we'll hear in a moment, this is happening in other countries as well. And I thank you, Amrit, for introducing our distinguished guests. And I look forward to learning about the conditions that have made that possible. And with that, I'll turn it over to Amrit to start the conversation. Thank you so much.
Thank you, Rebecca. We now invite Justice Barroso, Justice of the Supreme Federal Court of Brazil, to deliver his comments. Thank you.
Well, good afternoon for people who are in California. Good evening for people that are in South America. I'm pleased to be here and to share some ideas and some thoughts on this subject, the role of the judiciary in protecting electoral rights. I have divided my short presentation in three parts. Let me take note of the time. First one is dedicated to the world context. The second one to the role of the judiciary in Brazil in protecting electoral rights. And the third part, the threats of democratic recession that we have overcome in Brazil, fortunately. So starting with the world context, constitutional democracy was the winning ideology of the 20th century. However, something seems to have gone wrong in some part of the world in the past decade and a half or so, in a scenario that has been described, as Rebecca was saying, and hi Rebecca and hi Emery, thank you for the invitation. A scenario that has been described as democratic recession, an expression that is commonly used to identify the processes that occurred in countries like Hungary, Poland, Russia, Turkey, the Philippines, Venezuela, and Nicaragua in Latin America, I should say. I would like to say that populism and extremist populism can't be right-wing or left-wing, as we all know, but currently, right-wing extremism, often racist, xenophobic, and homophobic, has prevailed in different parts of the world. And authoritarian populism in different parts of the world deploy common strategies, which are basically, one, to establish a direct communication with their supporters, usually using social media, more recently using social media. Second, bypassing or trying to co-opt intermediary institutions like the legislature or the press. And in the third place, attacking the Supreme Courts and constitutional courts with the attempt to capture them and fill the seats with submissive judges. And on top of that, I should add, authoritarian populism also deploys as one of its main tools disinformation campaigns, hate speech, slander, character assassination, lies, and conspiracy theories. So this is a very brief description of how I see the rise of authoritarian populism in the world. Our second chapter, I would like to talk a little bit about the role of the judiciary in protecting electoral rights in Brazil. The first thing I should say, in Brazil, within the structure of the judiciary, there is an electoral justice. The electoral justice in Brazil is part of the federal justice system, and it's present in all states of the Brazilian Federation. So we have an electoral justice organized in three levels: trial level, appellate level, and there is at the top a superior electoral court, which I presided until recently. The electoral justice in Brazil plays two roles: an administrative role, which is the role of organizing and overseeing the elections, and a judicial role, which is deciding any sort of conflicts that may arise from the electoral process. This is maybe very unique of Brazil, to have the elections run by the judicial branch. And one other observation that is important, in Brazil since 1996, we have adopted a voting system using electronic ballot boxes without any sort of paper trail. The new system, this electronic ballot system just eliminated in Brazil for good the electoral frauds that previously occurred with the manual counting of paper ballots and the posting of results on electoral maps. So it's a very unique system, but the system in Brazil is totally electronic, and that has, as I said, eliminated any sort of fraud, which was very common in the past. No case of fraud since 1996 has been reported in Brazil. And finally, my last chapter, the threats that we have had in the recent past in Brazil regarding the democratic institutions. So as of 2018, Brazil experienced a period in which international organizations detected a democratic decline in the country. And in fact, there were several episodes that would scare many people, with the former president, attacking very harshly the press, some institutions, and very particularly attacking the judiciary, particularly the electoral justice and the Supreme Court. And there has also been a politicization of the armed forces, of the military, which is always very dangerous in Latin America. I don't have to tell you that. So with regard to the electoral justice, what happened was, although the president won the 2018 election by a large margin, he repeatedly made false accusations that there was fraud in elections and that he should have won in the first round. Brazil is probably the only country in the world in which the winner claims fraud. And he has repeatedly said that before the past elections, the 2022 elections, and many pundits observed that that was a strategy to call fraud in case the president would lose re-election. Besides accusing the system of fraud, the president launched personal attacks against several ministers of the Supreme Court, myself included, with criticism, offenses, and even a request for the impeachment of one of the justices. The president himself filed a request for impeachment. And finally, the president has supported a proposal to return to the paper ballot, which in Brazil has always been synonymous of fraud, with fraud. And on the day of the vote in Congress to go back to the paper ballot, which fortunately Congress did not approve, the president ordered a parade of war tanks in front of Congress and in front of the Supreme Court, which are one in front of the others, of the other. So this constant attack on institutions and the resulting discredit that it brought to the former president's supporters, I should add, led thousands of his supporters to invade the headquarters of the three branches of government on January the 8th, protesting against the results of the elections and, attempting a coup d'etat that, of course, did not happen. So in conclusion, in the Brazilian case, fortunately, the judiciary has played a decisive role in preserving democracy, the rule of law, and electoral rights. And the electoral justice, despite being heavily attacked, ensured free and clean elections, and the Federal Supreme Court invalidated acts by the president that violated the Constitution on various topics, from vaccinating people against COVID-19 to protecting the environment. So we were luckier here than Russia, Hungary, Turkey, and other countries where the courts lost the battle with the president. But I think we should keep watching. Authoritarian populism is still out there, and they're still attacking the institutions. I think that's what I had to say as a starter. Thank you very much for the invitation.
Thank you, Justice Barroso. We now invite Magistrate Salazar Marin, Judge of the Constitutional Court of Ecuador, to deliver her comments.
Thank you very much. Good afternoon and good evening to all of you. I know that time is very brief, but I have to start by thanking the Stanford Law School's Rule of Law Impact Lab and the Inter-American Dialogues Rule of Law program for organizing this event. Thank you so much, Professor Singh, Director Tarasiuk, President Bill Chavez, for this invitation. I feel really honored to share this space with all of you, and also with former Justice Sidney Blanco and with Justice Barroso. I will focus my brief remarks on the situation of Ecuador. And I should start by clarifying that in Ecuador, the Constitutional Court, where I work, is generally not concerned with electoral matters. There is an electoral court for that. However, 2023 has been a year of unprecedented constitutional and political change in Ecuador, and the court has played a very key role in a series of events that led to the anticipated elections that will take place this August in just a few weeks. So given the time and other restrictions that we have this afternoon, I will attempt to offer a very short description of these complicated events and the role played by the court, and I will divide it in 4 different moments. The first moment started in February 2023. Ecuadorians went to the polls to decide on a referendum proposed by President Lasso himself. He was proposing 8 measures in 3 main areas: security, institutional reform, and the environment. The Constitutional Court played a role because the court controls if the proposed questions can actually go to the ballot according to the rules in the Constitution. And some of the questions proposed by President Lasso, for example, those related to the militarization of security or the introduction of new crimes and some changes to the criminal code, those did not pass the test of the court, and they were not a part of this specific referendum. But the referendum went through, and the no won in all of the 8 questions proposed by President Lasso. And so this result really backfired against the government. There comes a second moment, March 2023. Congress started a procedure to impeach President Lasso. Again, the Constitutional Court played a crucial role because it's supposed to decide on the admissibility of this impeachment accusation. And the court studied the case and decided that 2 charges related to concussions, they were inadmissible, but there was 1 charge, it was related to the crime of embezzlement. The court found it admissible under a plausibility standard. And since one of the charges was admitted, it was up to Congress, not up to the court, to decide if the president is politically responsible of such accusations. This decision took a toll on the court because some people expected the judges of the court to act almost as a criminal court, even if the Constitutional Court is not allowed to judge on the merits of the accusation or on the sufficiency of the evidence, or on the veracity of the facts. We don't judge on the political or criminal or any type of responsibility of the president. We just have to decide the admissibility, but it's not up to the court to decide the future of the president. But of course, as a consequence of all the prohibitions that the court has to restrict itself, there is a big political impact of this decision taken by the court. So a third moment comes in May 2023, just a few days before Congress was ready to vote on the impeachment accusation. President Lasso decided to use a decree applying a provision that is included in our Constitution, which allows the president to dissolve Congress and call for anticipated elections, both for Congress and for the presidency, for himself, basically. This figure is commonly known in Ecuador as the cross death. And so the court played a fundamental role again because several parties asked the court to rule that such decree was against the Constitution. And the court decided those claims were all inadmissible as the Constitution does not provide for any judicial control of this decision when it's based on the specific grounds of political crisis. In fact, if the decree of the president had been based on other grounds, the Constitution expressly provides for a control by the court, but not on this specific ground. And so the court reasoned that this matter was not up to us as judges to decide. It is up for the people to decide in the next elections. And then we come to a fourth moment that started in May, and we're still living through it, where the court has been playing another critical role, because in the absence of Congress, the Constitution allows the president to issue decrees and to legislate, but only on urgent economical matters. And these decrees that the president can issue can only enter into effect if they pass a previous control of the Constitutional Court. So far, the president has proposed 4 pieces of legislation, and the court has allowed only 1 out of those 4 proposals to go through. And the other 3 decrees were considered by the court either not urgent or not constitutional on some other grounds. And so as a consequence of these events, the country will go to elections for a new president and for new members of Congress. In a few weeks, we should know the results. However, the long-term, the negative impact on the court's legitimacy, given this constant exposure to highly controversial political decisions in a highly polarized country like Ecuador, that remains unknown. And maybe we have time in the questions and answers to focus on this. So I wanted to explain what's going on in Ecuador and the role that the court has played. And I think my time is up. Thank you so much.
Thank you, Magistrate. We now invite Justice Blanco, former magistrate of the Constitutional Chamber of El Salvador's Supreme Court, to deliver his comments.
Buenas tardes. Muchas gracias por la invitación a participar en este evento muy importante. Quiero hacer un breve recorrido también acerca de lo que ocurre en nuestro país, en mi país, El Salvador. Los fraudes electorales contribuyeron a que en El Salvador se desatara una guerra civil en la década de los 80. El sistema judicial estuvo absolutamente invisibilizado para ejercer los controles. Los acuerdos de paz, después de 12 años de guerra, fueron las fuentes materiales para reformas constitucionales en los que se abordaron temas tan trascendentes como el sistema judicial y el Tribunal Supremo Electoral, creando una especie de simbiosis mediante el cual el Tribunal Supremo Electoral se reconoce por la Constitución como la máxima autoridad electoral, pero además deja expedito los recursos judiciales por violaciones a la Constitución para que sean conocidos por los tribunales encargados de juzgar asuntos constitucionales. Yo he sido juez por 25 años, 9 de los cuales formé parte de la Sala de lo Constitucional, en la que concurrí con mi voto a emitir muchas sentencias en materia electoral. Y voy a citar algunas para dejar en evidencia la importancia que tiene la presencia de los jueces en el control constitucional de las actuaciones de los tribunales electorales. En primer lugar, declaramos inconstitucional una ley electoral que obligaba a que para ser candidato a diputado era necesario estar afiliado a un partido político. La sentencia, basada fundamentalmente en la jurisprudencia de la Corte Interamericana de los Derechos Humanos, en 2 casos específicamente, Yatama versus Nicaragua y Castañeda Gutman versus México, reconocen la posibilidad de participación política de personas aunque no estén afiliados a partidos políticos. En segundo lugar, declaramos inconstitucional los artículos electorales que obligaban a que los ciudadanos debían votar en listas cerradas y bloqueadas. Esto impedía, sostuvimos en la sentencia, el carácter libre del voto y ordenamos a la Asamblea Legislativa que permitiera a los ciudadanos votar en listas abiertas, es decir, a seleccionar candidatos a diputados de diferentes partidos políticos. En tercer lugar, declaramos inconstitucional una ley que dejaba a discreción de los partidos políticos revelar o no los nombres y los montos de sus financistas. Creemos importante que los partidos políticos están obligados a revelar de manera transparente quiénes son sus financistas. En cuarto lugar, declaramos inconstitucional también una elección de miembros del Tribunal Supremo Electoral por tener vinculaciones política partidaria. Consideramos en la sentencia que los jueces electorales, al igual que los jueces ordinarios o cualquier otra persona que ejerza jurisdicción, debe de estar desvinculado de partidos políticos. Y por eso el mismo presidente del Tribunal Supremo Electoral fue declarado inconstitucional por pertenecer abiertamente a un partido político. En quinto lugar, declaramos inconstitucional un fenómeno también que se da en nuestra región, y es el transfugismo político. Este fenómeno que permite a los diputados llegar al poder por determinado grupo político, pero estando en el cargo se cambian de partido por razones distintas. El transfugismo político, que en otros ámbitos ha sido enjuiciado desde el punto de vista ético, nuestra Sala de lo Constitucional declaró que era prohibido cambiarse de partido durante el ejercicio de su mandato. En sexto lugar, mediante un amparo, la Sala de lo Constitucional ordenó el recuento de unos votos a solicitud o mediante demandas planteadas por unos candidatos que reclamaban fraudes o falsedad en los conteos. La Sala ordenó un recuento de votos e impuso como medida cautelar la obligación de abstenerse de tomar posesión los diputados que habían sido electos hasta que no se produjera el conteo. En séptimo lugar, en una sentencia, la Sala interpretó la prohibición de reelección sucesiva o inmediata. Hay una serie de disposiciones en nuestra Constitución que prohíben. Yo estoy convencido y estoy consciente que en otros ámbitos está permitida la reelección inmediata, pero en nuestro país la Constitución la prohíbe expresamente en más de 4 artículos, con frases tan radicales como que un presidente no puede permanecer en el cargo ni un día más, y una serie de disposiciones orientadas a la prohibición radical a la reelección. Por otro lado, dictamos una sentencia de inconstitucionalidad por la omisión legislativa de habilitar el voto de salvadoreños en el exterior. Esto fue a partir de 2016. También declaramos inconstitucional unas disposiciones legales que daban un trato desigual a los candidatos partidarios con los candidatos no partidarios. Por otra parte, declaramos inconstitucional un decreto ejecutivo emanado del presidente de la República, el presidente Funes, que autorizaba a los funcionarios públicos a participar en campañas políticas electorales. Hay una disposición en nuestra Constitución que prohíbe a los funcionarios públicos prevalerse de los cargos para hacer campañas proselitistas. Y esto es muy importante debido al compromiso que tienen los servidores públicos con el Estado y no con partidos políticos concretos. Por otro lado, también la Sala enjuició la constitucionalidad del sistema de conteo de votos, esta fórmula que permite la conversión de votos en escaño, y reconoció que este sistema de conteo de votos de cocientes y residuos es el que mejor se adapta a nuestro sistema de representación proporcional y se adapta al pluralismo que recoge nuestra Constitución. Pero estas sentencias solo pueden ser dictadas por jueces independientes. Para mí el tema transversal es la independencia judicial. La independencia judicial que tiene sobre su base los procesos de elección. Y esto lo recalco porque estas sentencias que dictamos por el tribunal del que formé parte en el 2009 a 2018, todo ha sido totalmente borrado por la actual Sala de lo Constitucional. En mayo de 2021, la nueva Asamblea Legislativa del gobierno del presidente Bukele, el mismo día que tomaron posesión, siguiendo la dinámica del Congreso de Ecuador hace mucho tiempo, removió a los miembros del Tribunal Supremo, del Tribunal Constitucional y al Fiscal General de la República. Ya conocemos la sentencia de la Corte Interamericana sobre el Tribunal Constitucional versus Ecuador. en donde los congresistas y aquí los diputados de la Asamblea Legislativa, sin causas específicas, sin derecho de audiencia, de manera fulminante destituyeron a los magistrados de la Sala de lo Constitucional y al fiscal general de la República. Y en su lugar designaron sin procesos, de manera contraria a la Constitución, a unos miembros de la Sala de lo Constitucional que han demostrado fidelidad y lealtad a las políticas del Ejecutivo. Queda en evidencia entonces que la independencia judicial es clave para garantizar los derechos humanos y para garantizar los derechos constitucionales. Todos ellos no pueden ser tutelados de manera cierta por jueces que están vinculados o que están sometidos o que se permiten las interferencias de los poderes políticos. En El Salvador, actualmente se ha creado un caos jurídico. La Sala de lo Constitucional y el Fiscal General de la República y, consecuentemente, los órganos judiciales y legislativos han sido cooptados por la Presidencia de la República. De tal manera que, desconociendo la jurisprudencia de la Sala de lo Constitucional que les he mencionado, ahora los nuevos magistrados han reinterpretado la Constitución y han determinado que el presidente Bukele puede postularse a una reelección, como en efecto lo ha anunciado. En febrero próximo tendremos elecciones y uno de los candidatos que están anunciados en el ring electoral es precisamente el presidente Bukele, a pesar de que la Constitución lo prohíbe expresamente. Es la misma política o la misma dinámica que han seguido otros gobernantes como en Nicaragua, Venezuela, Bolivia, Honduras, en donde los propios tribunales constitucionales alineados al poder político terminan interpretando la Constitución a carta. La Sala de lo Constitucional, de la que formé parte, emitió una serie de sentencias que, aunque no gustaban al poder político, pero creemos que es lo que corresponde a un juez constitucional, actuar con ética e interpretando las disposiciones constitucionales de manera actualizada y sobre todo tutelando los derechos fundamentales de los ciudadanos. Muchas gracias.
Thank you, Justice Blanco. If I may use the moderator's privilege now to ask each of the justices a question, following which we will pose questions collected in advance from the audience. Justice Barroso, the first question is for you. Do you see any parallels between the January 6, 2021 events in the United States and the January 8th, 2023 events in Brazil, including with respect to the role of the judiciary? Thank you.
Thank you, Emrit. Yes, most definitely. Many parallels, many similarities. I think many people would say that the former Brazilian president copied Donald Trump in many of his behaviors, I think I could say. And very typically, the allegations of fraud, even before the elections, the discourse was, if I lose, it's because there was fraud. And of course, after the elections, I only lost because it was rigged. I think another common trait was the non-concession. In Brazil, there is a tradition that the president that leaves hands a, I don't know the name in English, like a slash or a typical representation of the presidency to the incoming president, and the former president just left the country, went to Miami or to Orlando in order not to do that. And I think both, to a certain point, showed some sympathy for the invaders, for the people that had really attacked the institutions. So I think there were some common behaviors between both presidents. And I think both in the US and in Brazil, the judiciary played a very important role. In the US, as far as I know, there were over 60 lawsuits challenging the results and claiming for fraud or for voiding some elections in some states. And I know that 2 of them reached the Supreme Court. And as far as I know, none of them was granted. And the same happened in Brazil. The lawsuits that challenged the results were not accepted and didn't lead to any results. And in Brazil, there was an outcome, unlike the US, that it was very important and to a certain extent controversial, is that the Superior Electoral Court stripped the former president of his political rights. So he cannot run again for 8 years because of false accusations of fraud. And he was given the opportunity to show the evidence, which he never did. And we have a figure here in the electoral legislation called abuse of political power and abuse of means of communication. And if you are in office and you improperly deploy these powers, you may be stripped, you may be sanctioned, you may be stripped of your political rights. And this is what happened. So electoral matters. And I think in avoiding attacks to the institutions by wrongly and falsely claiming the occurrence of fraud, because of course, if you say that elections were rigged and you can convince a large amount of people, that brings discredit to the institutions and it brings discredit to democratic institutions. And of course, that paves the way for things as what happened on the January 8th, or, and this is a ghost that haunts Latin America, for coup d'etat. So we are very serious. We have a constitution that has been on for 35 years, and the Supreme Court and the Judiciary is very zealous of preserving it and preserving democracy in Brazil. So there are similarities. I think in both countries, the Judiciary was a part of containing any attempt of disrespecting the results. But maybe in Brazil, we went even farther, stripping the former president of political rights.
Thank you, Justice Barroso. Magistrate Salazar Marin, if I may turn to you next. To what extent are developments in constitutional courts and acting as a check on the abuse of executive power in Latin America relevant for the judges of other courts in that region?
Thank you for your question. I think it's very hard for me to say that what we are doing in Ecuador is relevant for other courts in the region, not only because our role and the political circumstances in Ecuador are so unique, but mostly I'm just not sure it's my place. But I can say, however, that the role that other courts in the region have played, acting as a cornerstone in periods of democratic erosion, has been truly encouraging for us. It has given us the stimulus to continue our work with independence. We know we need to make decisions based on the long-term impact of our precedents and not based just on the political circumstances or based on the fear of the repercussions of the lack of popularity of our decisions. We cannot make our decisions based on how the executive power is going to react. And so some other courts in the region, and we have here very good examples, they have been role models for us at the time of figuring out what is our role and preserving the rule of law in context of democratic backsliding. And so this is why an event like this, where we can join together with other magistrates who are facing similar experiences, is truly very useful and inspiring for us.
Thank you, Magistrate. If I may turn now to Justice Blanco. Justice Blanco, what relevance does a country's highest court's conduct in acting as a check on abuse of executive power have for lower courts in that country?
Yo creo que esta pregunta nos vincula con otro tema también de organización de los poderes judiciales. En El Salvador, el poder judicial está organizado de manera horizontal en los casos concretos. Sin embargo, la cúpula, es decir, la Corte Suprema de Justicia, le corresponde el régimen disciplinario de los jueces inferiores. Esto ha sido duramente criticado, porque los jueces inferiores se suelen alinear a las directrices emanadas de las Cortes Superiores. Y actualmente tenemos, como dije antes, una sala de lo constitucional que nosotros le llamamos con toda claridad señores que usurpan los cargos públicos porque no son verdaderos magistrados, no llegaron al cargo a través de los procedimientos constitucionales, ni se conocían sus credenciales, etc. Y obviamente, como estos magistrados de la Sala de lo Constitucional obedecen directamente a las políticas del Ejecutivo, también la Corte Suprema y la Sala de lo Constitucional, de la que forma parte, tiene amedrentado a los jueces. Es decir, los jueces no pueden actuar con independencia, sino que también deben de alinearse, y lo vemos especialmente en materia penal. Actualmente llevamos ya más de 15 meses bajo un régimen de excepción, en donde han suspendido garantías fundamentales y todos los jueces están alineados a las directrices que emanan del propio Ejecutivo. Por lo tanto, creo que actualmente la independencia judicial en el país, en cualquier nivel de conocimiento, está roto, está desvinculada de las obligaciones constitucionales. Y obviamente el Poder Ejecutivo ha cooptado no solo los poderes legislativo y Poder Judicial, sino también otras entidades como el Tribunal Supremo Electoral, como los tribunales de ética, como las instituciones de acceso a la información pública, como las Procuradurías para la Defensa de los Derechos Humanos. Hay una tendencia a apropiarse y a dirigir todas las instituciones y por lo tanto no hay una institución hoy en El Salvador que ejerza control objetivo, constitucional, razonable del Poder Ejecutivo.
Thank you, Justice Blanco. I will now read out a question that was submitted by the audience for you in advance. And the question is this: how concerned are you that at this point in the electoral calendar, the TSE, the Tribunal Supremo Electoral, has yet to issue an invitation to the OAS to set up an electoral mission to observe the February 2024 elections in El Salvador? Do you even expect the OAS to be invited? What guarantees as to the integrity of the electoral process and results can foreign observers offer, particularly in light of questions around the transparency of electronic voting by Salvadorans abroad?
Bueno, yo creo que mi participación ha sido categórica en mostrar una preocupación respecto al futuro de El Salvador por la suspensión de derechos fundamentales y por la poca transparencia y la rendición de cuentas y por la ausencia de los controles que corresponden a las instituciones. Yo no estoy ahora en condiciones de asegurar la pureza del proceso de elecciones para el próximo año. pero yo creo que hay elementos negativos o indicios que permiten sospechar de esa transparencia. Partiendo de lo que ya dije, de que el presidente, a pesar de existir prohibiciones constitucionales, ha anunciado su postulación para reelegirse, violando la Constitución. Por otro lado, de parte del Ejecutivo hay un desprecio a la oposición. Es un presidente que no respeta la oposición política y que no reconoce las minorías relevantes que se pueden producir. Es decir, la palabra pluralismo no existe en nuestro país en ninguno de los estamentos. El pluralismo ideológico que regula nuestra Constitución ha desaparecido en este gobierno del presidente Bukele. No es transparente ni tiene la cultura de rendición de cuentas. Los diputados y jueces están totalmente cooptados. Además, se han presentado unas modificaciones a las reglas electorales a última hora, sin debate, sin participación ciudadana, en aspectos electorales trascendentes, como por ejemplo, la reducción drástica del número de diputados. Hay todavía en nuestro país 84 diputados. Y de un día para otro, mediante una aprobación de una ley sin debate, sin explicaciones, sin posturas técnicas, redujeron a 60 diputados. Pero además de eso, redujo de manera inexplicable, sin debate, sin participación, redujo de 262 municipios a 44 municipios. Todo esto son elementos que permiten sospechar de que algo está tramando para las próximas elecciones. Claro, yo no estoy todavía en condiciones de descifrar todos estos movimientos de la pieza de ajedrez, pero también estoy con la seguridad de que todos los elementos y los comportamientos del presidente Bukele generan sospechas de su transparencia y de la pureza en los próximos eventos electorales.
Thank you, Justice Blanco. And now for questions addressed to all three of the justices, should you wish to respond. The question is, what mechanisms or practices could be implemented to eliminate political influence in the judicial system? Any of the justices, would you care to respond to that question?
I'll step in. I think I could say that the judicial branch in Brazil is very independent, possibly one of the most independent in the world, I would say, for the way we recruit judges here. So at the beginning of the career, at the trial level, judges are recruited through public competitive examinations and unidentified examinations. So if they pass, they get the job without owing anything to any political institution. It's a very private merit to become a judge in Brazil. And, you know, that renders the judiciary very independent because you have no political connections. Of course, as you climb to the appellate level, still you have the career judges that are promoted. So we are still talking about independent judges. And at the Electoral Superior Court, the way the Constitution structured it is very interesting. We have 7 judges at the Superior Electoral Court. 3 of the judges are Supreme Court justices. So we have 7 members. 3 of the judges are Supreme Court justices. 2 of them are judges from the High Federal Court, and 2 of them are jurists that are appointed by the President of the Republic, but out of a list that is prepared by the Supreme Court. So it's a very powerful court because it has 3 Supreme Court justices. And again, it's a very, very independent court. And that's the reason I think I could say, Amrit, that populist leaders attack the court because it's not submissive to the political powers or to majoritarian politics. Of course, and we need to be honest here, judges live in this world. And of course, you have your own idea of what's good and of what's right, but that's not partisan. But everyone has a dimension of an ideological view of the world that affects judging, but that's totally different from being subordinated to any political branch. So I think that Brazil, with all its difficulties, is a good model of organization of judicial system to assure independence to its judges, and I think it has worked pretty well for Brazil. As I said, we have many problems, but judicial independence is not one of them.
Thank you, Justice Barroso. And now the final question. In light of the foregoing discussion, and this question is for all 3 justices, in light of the foregoing discussion, what would you say are the lessons learned for constitutional or Supreme Court judges operating in the context of democratic decline? Any of the justices? Justice Salazar Marin, please.
Thank you. I will step in this time. First, if I may just take 1 minute to just say that I fully agree with Justice Barroso on that some of the mechanisms to eliminate political influence in the judicial system are related to the procedure to nominate justices. I could also add the measures to ensure financial or administrative independence of the courts. I will not go into detail because that question is in the past, but I wanted to add that in my experience, it's not so much a matter of constitutional design or legal mechanisms. It's also a matter of practice. I think politicians, on one hand, they need to understand that political decisions are to be made in the political arena. They should not pull the courts to the political arena. They need to understand that the courts decide matters basically, we decide matters on jurisdictional procedures. And these procedures are not often suited for such decisions, political decisions. And judges, on the other hand, they need to understand that the decisions of the court, they end up having a political impact, but the decision cannot be based on political grounds. And so now I'm going to move to your second question, because you said, what are the lessons learned? And for me, it always comes back to the question of self-restriction, being aware of who gets to make the final decision. For example, when the court in May was asked to rule that the cross-debt decree was unconstitutional, the court decided not to act, not to interfere. We decided in a matter of hours, 6 different cases, and the 9 judges agreed on all of these cases. And we did this because the Constitution has an explicit rule excluding us from that decision. Of course, it's always tempting, to have the power to influence these decisions. But what we reasoned is that these circumstances allow for the people and not for the court to arbitrate over political discrepancies between the executive and the legislative powers. And so it's the people who have to decide how, by electing their representative in these anticipated elections that will take place in August. So it's not a matter of judicial control, but a matter of democratic control that must be exercised by the people. It's up to the people to control their representatives through elections. And so, as I said, also one of the lessons learned is the long-term impact on the court's legitimacy. Giving this constant exposure to political decisions that are highly controversial in very polarized countries like ours, this can be very detrimental for the courts. A court needs to have a basis of legitimacy in order to make this kind of jurisdictional decisions that have such a political impact. And the Ecuadorian court, unlike some of the other courts that we have heard, we are a very young court. We just started building up this legitimacy in 2019. And so I'm actually afraid that this credit has been spent during this political crisis this year, and we are again at ground zero, and we need to like rebuild that legitimacy almost from scratch.
Thank you, Justice. Thank you, all of you. We now turn to Tamara Tarasuk-Brunner, who is the Rule of Law Program Director at the Inter-American Dialogue, and she will deliver some closing remarks. Thank you all very much.
Thank you, Amrit, and thank you everyone for joining this conversation today. I'll be brief and I'll just highlight we heard today from very distinguished panelists about the distinct, very different roles that have been played by the judiciary in an array of electoral contexts in Brazil, in Ecuador, and El Salvador. And all of you have pointed to a common thread, and that is then when there's a threat to democracy, judicial independence is key. And this goes well beyond these three countries. We've seen this be an issue in Argentina, in Mexico, today in Guatemala, in other countries as well. This is a very critical topic for the region. And we've heard a lot in Latin America about the politicization of judicial systems, about the political use of courts to go after opponents, not only in dictatorial countries, but also with what some politicians call lawfare. And I'd like to offer as a conclusion of this conversation that judicial activism is not necessarily a bad thing for the rule of law if what judges are doing is setting the democratic limits within which political actors must operate. And we need judges to do that. This is a very difficult job to carry out in polarized environments, as you have mentioned right now. And that is certainly the case, not only in Ecuador, but in Latin America and the Caribbean generally, and in particular in electoral contexts. But it is a much needed task, and judges who do this very bravely, and they must receive the support from all of us who care and are concerned about democratic decline in the region. I'm convinced that at this point in time, we are all pretty tired of the diagnosis that there is democratic backsliding in Latin America, and we need to shift the conversation into one about early warning signs that can help curb that democratic backsliding. And the active role of an independent judiciary in electoral contexts by upholding the legal norms that set the rules of the game and that put judges in a situation in which they're acting as a check on executive power. In this context, when there are attempts to undermine people's right to vote, the right to have free and fair elections is precisely that. It's an early warning that trouble is on its way. And that's precisely why authoritarian leaders have been quick to undermine judicial independence when this independence challenges them. So I really hope this conversation, which we will share widely, so those who couldn't make it today won't miss it, will be able to contribute to supporting the critical role that independent courts can play in our region. And I want to close by thanking you, Amrit, and the Stanford Rule of Law Impact Lab and the law school team for this partnership. I want to thank our fantastic panelists for participating today in their very busy schedules. We will continue to be holding events as part of these election series and our partnership with Stanford to highlight new and interesting angles to cover elections in the region. So please check out our websites and our social media for the next one. And thank you very much for joining.